Administrative Decisions from the USPTO for the Intellectual Property Research course at Boston College Law School. Procedural matters relating to the denial of a patent or trademark can be appealed to the Commissioner of Patents or the Commissioner of Trademarks and were reported in the Decisions of the Commissioner of Patents from 1869 until 1968, when they stopped publishing those books. Decisions published in those books are available to us in Hein Online in the Intellectual Property Law collection. Select Federal Agency Decisions and scroll down. Use the link to Decisions of the Commissioner of Patents. This is the title page from the 1968 volume. Today, USPTO decisions are available on the USPTO website, in part because of the Freedom of Information Act. Scroll to the bottom of the page to take the Freedom of Information Act link. The Freedom of Information Act page provides links to legal decisions, including the administrative decisions of the USPTO. Let's start with the Commissioner of Patents decisions. Final decisions from the Commissioner for Patents are organized by topic, linking to the decisions on the subject patent term extension or adjustment under 35 U.S.C. 154. We see these decisions are in patent number order. Let's look at the decision from March 1st, 2019. It looks a lot like a letter. The body of the letter is divided into background, calculations, and a conclusion. It was signed by an attorney from the Deputy Commissioner's office. Moving from patents to trademarks, we see that decisions on trademark petitions to director are only indexed by date and are not precedential. To view a decision, click on the month and retrieve a PDF file that lists the decisions chronologically. Clicking on a serial number link retrieves the record from the Trademark Status and Document Retrieval database. Under the Documents tab, click on Petition to the Director Granted or Petition to the Director Denied to see the decision. This decision of the Commissioner of Trademarks is divided into facts, discussion, and decision, and is signed by an attorney advisor from the Office of the Deputy Commissioner for Trademark Examination Policy. Final decisions of the Patent Trial and Appeal Board from 1997 to date are available on the USPTO website. To search the decision, select All PTAB Decision Data. To browse by topics, select Precedential and Informative. PTAB decisions are organized by subject matter in an expandable table. Under each subject, decisions are classified as precedential or informative. Let's look first at an informative decision and then a precedential decision. PTAB opinions look a lot like court opinions. Informative opinions are not binding, but illustrate norms of board decision-making. This decision is very clearly marked informative at the top. Opinions designated as precedential are binding on the PTAB. The purpose of a precedential opinion is to create a consistent line of authority as to a holding that is to be followed in future board decisions. Precedential decisions are clearly labeled as such. There is a link to this PTAB Final Decision Search page from the PTAB Decisions page, the Precedential and Informative Decisions page, and the FOIA page. The page loads with the latest month's decisions. There's a text search box at the top. Change the sort order by clicking on a column heading. You can search by proceeding number, patent number, application number, or publication number. There are also a number of facets you can filter by: names, proceeding type, decision type, e.g. affirmed, reverse settled, issue type, and board rulings. This was the cover letter that appears at the top of a 2015 appeal decision. This decision on appeal looks quite a bit like any reported decision from an appeals court. Some are short, some are long. The names of the administrative patent judges appear at the beginning of the decision. Final decisions of the Trademark Trial and Appeal Board are also available in a searchable database accessible from the FOIA page. The sortable columns also represent the facets or searchable fields of this database. Clicking on a proceeding appeal number to download the decision in PDF. Again, only those decisions labeled as precedential are binding on the agency. The TTAB can only determine the right to register, not the right to use. The TTAB is also responsible for cancellation proceedings against registered marks and concurrent proceedings usage.